Hello, my name is Loveleen Bhular and I will be presenting the module Principles of Environmental Law. The objective of this module is to introduce you to three ideas: the concept of sustainable development, the precautionary principle or approach, and the polluter pays principle. Let us begin with sustainable development. As early as in 1962, a United Nations General Assembly resolution encouraged governments to pay attention to natural resources management early into a phase of economic development. This thought continued into the Fornex Report of 1971, and in the year 1972, the Stockholm Declaration, one of the main outputs of the United Nations Conference on Environment and Development, called on states to adopt an integrated and coordinated approach to their development planning so as to ensure that their development is compatible with the need to protect and improve the human environment. This was followed in the year 1980 with the World Conservation Strategy, which identified the need for integration of conservation and development to ensure that modifications to the planet do indeed secure the survival and well-being of all people. As we can see, indirectly, each of these instruments is highlighting the concept of sustainable development, although the term itself is not specifically employed. In the year 1987, the Brundtland Report, or the report also known as Our Common Future, defined sustainable development as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. The idea which is highlighted here is the idea of needs, and this is a reference to the essential needs of the world's poor being an overriding priority. There is also a concept of limits which are not absolute, and the report also highlights the interaction of present state of technology and social organization on natural resources and the ability of the biosphere to absorb the effect of human activities. The concept of sustainable development was then included in the Rio Declaration of 1992. A number of principles of the Rio Declaration reference this idea. For example, Principle 1, which states that human beings are at the center of concerns for sustainable development and that they are entitled to a healthy and productive life in harmony with nature. Principle 4, which states that in order to achieve sustainable development, environmental protection shall constitute an integral part of the development process and cannot be considered in isolation from it. Also, we have Principle 3 of the Rio Declaration, which states that the right to development must be fulfilled so as to equitably meet developmental and environmental needs of present and future generations. What we see here is a clear link being drawn between economic development and environmental protection, keeping human beings at the center of this discussion. In the year 2002, one of the main outputs of the World Summit on Sustainable Development held in Johannesburg, South Africa, was the Johannesburg Declaration on Sustainable Development, and it states, and I quote, "We assume a collective responsibility to advance and strengthen the interdependent and mutually reinforcing pillars of sustainable development: economic development, social development, and environmental protection at the local, national, regional, and global levels." We see here a move further from the discussion being restricted to economic development and environmental protection, with the inclusion of social development as the third pillar of sustainable development. One of the few instances where the concept of sustainable development has been considered by the International Court of Justice is the 1997 case concerning the Gabcikovo-Nagymaros project. The parties to this case were Hungary and Slovakia, and the case concerned a treaty to build a series of hydroelectric dams on the river Danube. Both of the parties, Hungary and Slovakia, referred to sustainable development in this case, and the ICJ noted this need to reconcile economic development with protection of the environment is aptly expressed in the concept of sustainable development. For the purposes of the present case, this means that the parties together should look afresh at the effects of the environment of the operation of the Gabcikovo power plant. What is also of note in this case is the separate opinion given by Vice President Veeramantri, who noted that the right to development does not exist in the absolute sense. It is relative always to its tolerance by the environment. According to him, right to development is clearly part of modern international law, and this is compendiously referred to as sustainable development. Another decision of the International Court of Justice from the year 2006 is the pulp mills case Provisional Measures. The parties to this case were Argentina and Uruguay, and this case, according to the ICJ, highlights the importance of the need to ensure environmental protection of shared natural resources while allowing for sustainable economic development. According to the court, it is necessary to bear in mind the reliance of the parties on the quality of the water of the river Uruguay for their livelihood and economic development, and account must be taken of the need to safeguard the continued conservation of the river environment and the rights of economic development of the riparian states. The Supreme Court of India has also applied the concept of sustainable development in a number of cases over the years. While in the late 1980s, the approach of the Supreme Court was a compromise approach in disputes concerning termination of mining leases, during the 1990s, the Supreme Court adopted a more environmental focus. More recently, there has been a shift towards an anthropocentric or ecocentric basis of sustainable development. The Article 21 right to life has been read broadly by the Supreme Court to include the right to environment and the right to development. In a 1991 decision of the Supreme Court in the case of Rural Litigation and Entitlement Kendra versus State of Uttar Pradesh, the Supreme Court observed that if a just balance is not struck between development and environment by proper tapping of natural resources, there will be a violation not only of Article 21 but also Articles 14, 48A and 51G of the Constitution of India. One of the important decisions in this regard is the case of Vellore Citizens Welfare Forum versus Union of India and others, a 1996 decision of the Supreme Court. This case arose in the context of a suit in response to reports that tanneries were discharging effluents into the river Palar in the state of Tamil Nadu, where this river was a main source of drinking water supply. The Supreme Court made a number of observations with respect to sustainable development in this case. For example, it noted that the traditional concept that development and ecology are opposed to each other is no longer acceptable. According to the court, sustainable development has been accepted as a part of customary international law, though its salient features have yet to be finalized by the international law jurists. Supreme Court also identified certain salient principles and essential features of sustainable development, such as the precautionary principle and the polluter pays principle, both of which will be discussed in the course of this presentation. Finally, the Supreme Court noted that notwithstanding the economic benefits of the leather industry, which was responsible for the discharge of these effluents, economic interests cannot be allowed to destroy the ecology, degrade the environment, and pose a health hazard to the public at large. Moving on to the second principle which we are discussing today, which is the precautionary principle, also known as the precautionary approach in certain cases. A brief background about the precautionary principle first. The origins of the precautionary principle can be traced to Swedish and German environmental law and policy at the national level. Subsequently, it was mentioned in the World Charter for Nature of 1982, the North Sea Conference of 1984, and at the regional European Community level in the Brundtland Ministerial Declaration on Sustainable Development of 1990. In the year 1992, In the course of the Rio Declaration, the precautionary principle was specifically taken note of in Principle 15. I will now quote Principle 15 of the Rio Declaration. It states that in order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. Here we see a shift away from using the language of principle towards considering the concept of precautionary approach. This formulation of the precautionary approach does not have a normative character of a rule of law, and it is phrased in very general terms. What it does is to help identify whether a legally significant risk exists by addressing the role of scientific uncertainty. But it also fails to do certain things. For example, it does not state what the measure should be, how the risk should be controlled, and what level of risk is socially acceptable. The reason for adopting the concept of an approach rather than a precautionary principle was at the insistence of the United States, because it was felt that the use of an approach rather than a principle offers greater flexibility and is less potentially restrictive. However, the difference between an approach and a principle is quite significant, because there are higher uncertainty and costs where there is a risk of irreversible harm, and there is a significant level of uncertainty and potential cost, the harm is less irreversible. So we find two sets of trends. When you look at the European treaties and the European Community law, they use the language of a precautionary principle, but when you look at international environmental agreements, often the language used is that of a precautionary approach or a precautionary measure. We also find a strong version and a weak version of the precautionary principle or approach. In the strong version, the potentially risky activity is banned. The burden of proof is on the proponent of the activity to demonstrate that the activity is benign and that it poses no or acceptable risk. However, it is felt that the adoption of such a strong version of the precautionary principle may stifle innovation and creativity, hamper scientific and technological advancement, and result in regulatory paralysis. This is the view held by a foremost academician, Cash Sunstein. This strong version of the precautionary principle is not supported in international law, but it has been supported by the Supreme Court of India in cases such as the Vellore case. The weak version of the precautionary principle states quite the opposite. The potentially risky activity is not banned, the burden of proof requirements are quite different, and therefore they still allow the room for innovation and creativity, which is one of the main concerns of the strong version of the precautionary principle. Principle 15 of the Rio Declaration, which talks about precautionary approach, has been widely endorsed by states. For example, in Agenda 21, one of the other major outcomes of the Rio Conference of 1992, it has been applied or endorsed by a growing number of international organizations and treaty bodies as a matter of policy or in the form of legally binding treaty principles and subsidiary rules. However, the thresholds of harm are different in different international environmental agreements. For example, in the United Nations Framework Convention on Climate Change, there must be a risk of serious or irreversible harm before the precautionary measures can be adopted. The Principle 15 idea of precautionary approach has been used in the International Court of Justice. For example, in the Gabcikovo-Nagymaros case, this idea was relied on by Hungary. It was referred to with approval by Judge Veeramantri in his dissenting opinion. However, there was no reference by the International Court of Justice decision, although it was willing to apply new norms of international environmental law. In the pulp mills case of 2006, the idea of a precautionary approach was referred to in the dissenting opinion of ad hoc Judge Vinuesa. Principle 15 has also been applied in the decisions of the World Trade Organization, by the International Tribunal on the Law of the Seas. However, Whether or not it is customary international law has been discussed, for example, in the WTO asbestos case, where the European Community argued that it was a customary international law principle, but this was not accepted by the appellate body of the World Trade Organization. More recently, in the year 2011, the Seabed Disputes Chamber, while hearing the advisory opinion on responsibilities and obligations of states sponsoring persons and entities with respect to activities in the area, observed that the incorporation of the precautionary approach into a growing number of international treaties and other instruments, many of which reflect the formulation of Principle 15 of the Rio Declaration, has initiated a trend towards making the approach part of customary international law. The number of issues associated with the precautionary principle or the precautionary approach. That changing the role of scientific data in environmental cases is the first one. The other problem is that this approach or principle is not applied universally. There are uncertainties in the meaning, application and implications of this principle, and the concept of precaution means different things in different contexts in terms of identification of risk, how to respond to that risk, etc. Also, in terms of what do the states have to do when they apply the precautionary principle or the precautionary approach presents another problem. Are the states required to act? Are they empowered to act? And are they encouraged to be more cautious? Are some of the questions which are often left unanswered. As I mentioned previously, in the context of domestic environmental jurisprudence, the precautionary principle has been invoked in the Vellore case, and three fundamental elements were noted by the court. The first being that the principle requires the state to take environmental measures to anticipate, prevent and attack the causes of environmental degradation. Second, where there are threats of serious and irreversible damage, lack of scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. And third, in terms of burden of proof, the onus of proof is on the actor or the developer or the industrialist to demonstrate that the proposed action is environmentally benign. The idea of precaution has also been invoked in other Supreme Court decisions. Some of them include Andhra Pradesh Pollution Control Board versus M.V. Naidu, a 1999 decision where the principle was used to emphasize the need for scientific inputs before adjudicating complicated issues of environmental pollution. In the 2002 decision in T.N. Godavarman Thirumalpad versus Union of India and others, where the court referenced the principle of proportionality, which requires a balancing of priorities of development and environmental protection, and a 2006 decision in the T.N. Godavarman Thirumalpad versus Union of India and others case, where the principle was used to advocate general precautionary measures by the Supreme Court of India. We now move on to the polluter pays principle. The origins of the polluter pays principle can be traced to economic theory, which states that the producer should bear the cost of externalities such as environmental pollution resulting from the production or consumption of the good or service produced by him or her. In terms of polluter pays principle as a legal principle, it is useful to look at some of the early recommendations of the Organization of Economic Cooperation and Development, which promoted the partial cost internalization approach towards the polluter pays principle. It basically constitutes of two concepts. One is the cost allocation principle and the other is the non-subsidization principle. The cost allocation principle is based on improving efficiency and encouraging rational use of scarce natural resources. Here, the government is responsible for deciding pollution prevention and control measures to ensure that the environment is in an acceptable state, and the polluter is required to internalize or bear the full cost of carrying out these measures. These costs should then be reflected in the cost of the goods or services which cause the pollution. In this case, nothing has to be paid to anyone. Therefore, when we state that the polluter pays principle is being applied, no actual payment is being made. The other important element of this partial cost internalization approach of the OECD is the non-subsidization principle. The idea is to avoid distortions in international trade and investment arising from adoption of differential pollution abatement mechanisms or methods by the polluters. It's based on saying no to government subsidies. However, exceptions or special arrangements have been made possible. In other words, the polluter pays principle does not apply in absolute. Exceptions have been envisaged to it. The other element of the OECD approach follows a wider scope of the polluter pays principle. This is known as the full cost internalization approach, which includes the costs of accidental pollution caused by hazardous installations as well as control, cleanup and rehabilitation costs. This is reflected in the 1989 recommendation of the OECD. Subsequently, the 1991 recommendation of the OECD also talks about internalization of damage costs. At the international level, the important source of the polluter pays principle is the Rio Declaration of 1992. Principle 16 of the Rio Declaration states that national authorities should endeavor to promote the internalization of environmental costs and the use of economic instruments, taking into account that the polluter should, in principle, bear the cost of pollution with due regard to the public interest and without distorting international trade and investment. If you look at this statement, the responsibility is cast upon national authorities. Therefore, this discussion is taking place at the international level. The national authorities should endeavor to promote. Therefore, the obligation is not absolute or obligatory in nature. The Rio Declaration formulation goes beyond the OECD definition because it's not just speaking about internalization of environmental costs, but also the use of economic instruments. It then asks national authorities to take into account the use of very non-binding language, also talks about bearing the cost of pollution, which seems to suggest the full cost internalization approach, suggesting a wider meaning of the term cost in this case. The Principle 16 formulation of the Rio Declaration has been applied at the international level and the regional level widely. However, the content and legal status of the polluter pays principle remains unclear. It's not an absolute principle, as I stated before, because a number of exceptions are permissible. In marine agreements, both at the international level and at the regional level, parties are required to apply the polluter pays principle, and this language is included in the binding operative provisions of these agreements. In other cases, however, it is used in the form of guidance, therefore suggesting a softer language of the polluter pays principle. The language of the polluter pays principle is also included in environmental liability agreements. In some cases, it is referred to a general principle as well. For example, in the preamble to some conventions, as well as in the International Court of Justice decision in the North Sea Continental Shelf case of 1969. Insofar as domestic environmental law is concerned, we find explicit as well as implicit references to the polluter pays principle. We are going to discuss two decisions of the Supreme Court of India, but subsequently the polluter pays principle has been explicitly mentioned in a number of other Supreme Court decisions, decisions of high courts, as well as decisions of the National Green Tribunal. Another element of the polluter pays principle is its specific inclusion in legislation such as the National Green Tribunal Act, which requires the National Green Tribunal to consider the polluter pays principle as well as the precautionary principle and sustainable development while issuing its orders, etc. We will first talk about the Bichri case. In this case, the Supreme Court said that the polluter pays principle has now come to be accepted universally as a sound principle and has gained almost universal recognition. This observation of the Supreme Court was based on a journal article discussing the polluter pays principle in the context of the OECD and the European Community. In other words, the Supreme Court is looking at the polluter pays principle as a general principle of law prevalent in other systems. There is no reference to international environmental law such as the Rio Declaration, and there is no reference to the provisions of either the Constitution of India or domestic environmental legislation in order to explain the inclusion of the polluter pays principle. The Supreme Court then went on to observe that in light of the application of the polluter pays principle, the offending industry is responsible for repairing the damage caused by it. This decision of the Supreme Court has been subsequently referred to in a large number of decisions. The other important decision of the Supreme Court where the polluter pays principle was expressly mentioned for the first time is the Vellore case. In this case, instead of relying on the OECD and the European Community as was done in the Bichri case, the Supreme Court relied on two sources of the polluter pays principle. Number one, implicit inclusion of the polluter pays principle in the constitutional provisions relating to environmental protection as well as in environmental legislation such as the Water Prevention and Control of Pollution Act 1974 and the Environment Protection Act 1986. The Supreme Court also relied on the status of the polluter pays principle as customary international law. There was no reference to the Rio Declaration in the Vellore case either. It is pertinent to mention that in this case, the Supreme Court, although it states that the polluter pays principle is a principle of customary international law, this is not the general practice. The polluter pays principle has not yet been established as customary international law. As I mentioned previously, the polluter pays principle has been included in domestic legislation as well. In addition to the National Green Tribunal Act, we also must refer to the Hazardous Waste Management, Handling and Transboundary Movement Rules of 2008 and similar rules for electronic waste which were published in the year 2011, both of which state that certain entities are responsible for preventing environmental damage and they are liable in case of their failure to do so. There are a number of issues which must be discussed in the context of the polluter pays principle. Firstly, who is a polluter? Is it an industry, the government or members of the public? What does the polluter have to pay for? Past, present or future pollution? When is the obligation to pay triggered? When violation of an environmental standard takes place and there is occurrence of actual harm? Where there is violation of an environmental standard without occurrence of actual harm, what is known as the potential to harm. The occurrence of actual harm without violation of an environmental standard could also result in the invocation of the polluter pays principle. The next important question is how to determine payment. Should it be a percentage of annual turnover formula or absolute liability principles, etc. What is to be paid by the polluter is also an important question. Should it be monetary compensation to victims, costs for environmental damage to affected persons or into a government managed fund, or punitive or exemplary costs? The final question is who has to actually pay? Since it is the polluter pays principle, the traditionally held view is the polluter has to pay, but in certain cases the government may have to pay, or in certain other cases the costs may actually be passed on to members of the public. Finally, before concluding the presentation, we should also discuss the concept of liability. There are two main forms of liability: fault-based liability, where the proof of the polluter's negligence is required, and no-fault liability, where the burden of proof is reversed. There are two main forms of no-fault liability: strict liability and absolute liability. While strict liability is subject to certain exceptions, this is not the case insofar as absolute liability is concerned. Further, in case of strict liability, there is a cap on liability, which means that beyond a point the polluter cannot be made to pay, whereas in case of absolute liability, the liability amount is uncapped. Both of these concepts have been applied in the context of domestic environmental jurisprudence. In summary, this presentation has familiarized you with three ideas: sustainable development, precautionary principle or approach, and the polluter pays principle. In the context of each of these three concepts, principles or approaches, as the case may be, we have noticed that there have been considerable developments in the context of international environmental law, which has subsequently also found a place in domestic environmental jurisprudence. However, a number of issues remain outstanding in the context of each of these three concepts, principles, or approaches. Thank you.